By the looks of things, it's time for Legal AF After Dark. Judge Chutkan is going to have to get that case against Donald Trump restarted now that the Supreme Court has made its ruling in immunity. And yes, there's a case left, and it's up to Judge Chutkan to figure out how much of the indictment, how many of the overt acts that are listed there, and how much of the 4 counts against Donald Trump are going to survive the immunity decision. It's all on her shoulders as the presiding judge with the mandate back from the United States Supreme Court. Earliest she can hold such a hearing with the other lawyers and Donald Trump there as well would be about August the 2nd. We break it all down for you. The pile up of motion practice that Judge Chutkan's going to have to decide on and make short work of, and how she logistically sets up the potentiality for a trial of Donald Trump, at least before the inauguration. Break it all down on Legal AF, the podcast. Take a listen. Why don't we kick it right off with Chutkan? And why don't you give it from your perspective about the reason it's going to be early August is that there's a certain amount of days between the Supreme Court ruling on July 1st to answer the question that came up in the chat and in other places that I've seen. Like, is it immediately enforceable? Is it immediately the law of the land? Not exactly. There's 32 days plus 7 days. Once you're done with that, before that mandate becomes the mandate and gets direction back to Judge Chutkan, you're looking at Friday, August 2nd, Monday, August 5th, as the time she could pull the lawyers in and talk about how to move this case forward. We know what the two sides are going to say. What do you think, Judge? How do you think Judge Chutkan, who we've always admired in terms of her ability to deftly handle procedure and law and the administration of justice in her courtroom, what do you think she does day one once she gets everybody back in early August?
I think the first thing she does is just really remind everyone where we are, because the case wasn't quite ready to go to trial at the time that they pressed pause, at the time that Donald Trump appealed midstream and appealed and made a presidential immunity claim to the DC Circuit. And what happens is that forces her to press pause, because there's case law that suggests that a criminal defendant can't be made to work on a case when it's on appeal. And so it kind of divests you of jurisdiction at the trial court level, because the appellate court has jurisdiction over the case at that point. And so there were several motions that she still had to rule on. So I think that's the first thing she's going to talk about, is just tell everyone, okay, just so that we're all on the same page, let's talk about all the things that still need to be decided, right? And I think there were all sorts of motions. There were motions in limine, which were sort of pretrial motions about things if you remember, this was what Jack Smith filed after the stay, and basically was like, well, we can still keep working, and so they filed it, and then Donald Trump objected to that, and she kind of admonished the prosecution and said, a stay is a stay. Don't file any more motions. But there's those motions in limine that she has to talk about. She has to make sure that there's all sorts of discovery motions that Trump filed that she hasn't ruled on, and some allegations in the indictment, I think, also were still outstanding, if I remember correctly. And I think there was also a SIPA issue in this case, which I always forget about, because it is this isn't a SIPA case, the Classified Information Procedures Act. That I always think of the Mar-a-Lago case, which dictates when you want to use classified information, what has to be done, the procedures that have to be put in place in order to determine whether that can be used at a trial. I was looking back over my notes in preparation for this evening, and if I remember correctly, the SIPA ruling had not happened yet either. So I'm probably missing some, but those were the ones that stuck out to me, that the pretrial motions that she still has to rule on. So I think she's going to make sure that everyone's on the same page about that. I wonder whether she has decided, the ones that were fully briefed, whether she has those decisions. And if so, I anticipate she'll hand those down as well. And then, of course, there is what she has to do with respect to the Supreme Court ruling on presidential immunity. She's going to determine exactly how that's going to be handled, because certain things in the indictment are clearly out, and other things I think she's going to have to make a determination whether they are official acts, and then therefore they would be out of the indictment and out of the case. They can't even be used as evidence, or unofficial acts. So that's something else she's going to have to tell the parties or hear from the parties. How should she do that? I think it will be through a hearing. And I think it'll be a hearing where the special counsel puts on evidence, and then she will make a determination. But I think what they'll talk about is more of a procedural, how it will happen and when it will happen. I think she'll do it quickly. And finally, I think she also has to apply the Fisher versus United States case that also came down by the United States Supreme Court, which agreed with Judge Carl Nickel when Judge Nickel, who is in the DC trial court level, ruled that the January 6 cases you could not use 18 USC 1512, which is obstruction of official proceeding, in many of those cases, because they require some sort of documentary or document obstruction. You can't just obstruct by barging into Congress and threatening to kill the person who's trying to hold the official proceeding. That's not enough. It has to be through some sort of paper or document or evidence like that. And so she's going to have to apply that that interpretation, I should say, of the law to the two of the four counts that Donald Trump is charged with here of obstruction of an official proceeding. So she has a lot of work to do. I think she'll do it quickly, and a lot of these motions have already been briefed, but some, like the presidential immunity, they have some work to do there. So I think she'll set a motion schedule for what needs to have to still be briefed, and she'll set a hearing schedule for what there need to be hearings, and I think she will move this along quickly. That's how I see it happening.
Yeah, I think you're right. I think that it's not going to be a Judge Cannon special down at Mar-a-Lago, where things that should take, I mean, what Judge Chutkan has demonstrated that she will do in weeks has taken Judge Cannon years, and she hasn't even done it yet. And so I think you're right. The things that were fully briefed at the time the pin was put in the case in December, it's hard to believe, December 2023, she's going to pull the pin and she's going to issue her rulings. The ones that were half briefed, she's going to set a briefing schedule and give people time to do it. She had originally said, when she put the pin in, that whenever she got the case back, she was going to add 89 days. That was about the time that was left on the clock in the prep, that 7-month prep that she had originally established for the parties, mainly Donald Trump. And I think she's going to stick to that. She's going to say, we got 90 days to put this case on for trial, which would mean September, October, November. What else is happening in November of 2024 that may make Trump's lawyers apoplectic? Oh, right, the general election. So there's going to be that fight. And she'll say, all right, well, we'll do it in December then. Or we'll do it in October then. You want less time? I mean, we're going to see how much how chastened she may be, or singed a bit, now that the Supreme Court has come down so strongly against her original position and that of the DC Court of Appeals. There's no other way to put it. They threw out the entire president with the bathwater in the way that they ruled. And they didn't admonish the judge, but they did say, well, these were issues that you really should have done with a better record and development at the top of the case. And since you didn't do it, Judge Chutkan, and the DC Court of Appeals couldn't do it, we're left with you having to do it now. I mean, there was a little bit of smarmy knuckle rapping by the Supreme Court, and now she's going to, well, we'll see. I don't think she's going to come in beleaguered. I don't think she's going to come in with her tail between her black robe. I think she's going to do her job. And now have been given instructions by the Supreme Court. And I agree with you. I don't think she has a choice but to hold an evidentiary hearing and allow the evidence to be put on to help her sort this waterfall of overt acts into the three buckets. I know that the Trumpers, it's already leaked out, Chris Keiss and Blanche and whoever else is going to show up are going to argue that no evidentiary hearing. No, we can do it on the briefing. We can just brief And she's going to say, yeah, I don't think so. I think that I got to make a proper record. You asked for a proper record. You're going to get a proper record. Be careful what you ask for. I think it's going to be a little bit of that. And on a very short, expedited basis. And then the Department of Justice has got some thinking to do too, and Jack Smith, about whether he's going to take a red pen or a blue pencil to his own indictment and say, all right, I'm not going to die on this hill. I'm going to make, in terms of my own credibility, I'm going to make the decision, and I'm going to strike a handful of the overt acts, because I think, based on the ruling and the things that they said, I'm dead on arrival on some of them, not all of them, of course, not all of them. And then argue it's still what's left of the indictment still supports all of the 4 crimes. And I think he'll do that. I don't think he's going to say, no, let's just roll the dice and see what the judge is going to say. I think he'll want to maintain his credibility. Now, he still has just one thing to lay out here. If this goes kind of awry for him, the statute of limitations on these crimes have not run. I'm not saying he's going to rush back to open up a new grand jury and get a new indictment now consistent with the guidance or the rule of the Supreme Court, but he could. Of course, that would delay everything, because now we're basically etch-a-sketching this and shaking it to blank and now have to start all over again. Could do it. I mean, that's another tool in the prosecutor's tool bag. I don't think he's going to do that. I think he's going to blue pencil this and say, this is what should survive. This is what we're arguing for. And it supports all 4 of the counts. And then they're going to make the argument that right there on page 8 of the July 1st decision, Your Honor, is exact. And if you read that in conjunction with Sotomayor and even Amy Coney Barrett, it gives you the guidance you need to thread this needle. False evidence. They took the time to write false evidence citing a Sotomayor case, when she was in the Second Circuit, is enough to support a claim of interference with an official proceeding. And what are the false electoral certificates other than false evidence to try to interfere with an official proceeding, which in this case is the count? It's a very good argument, and I think it's one that should prevail in her courtroom and with the D.C. Court of Appeals. If it ever gets back to the Supreme Court, that's the delay problem, right, Karen? She makes her ruling. They don't like it. The loser, which will be Trump, will take another appeal, ask for a stay. If he doesn't get the stay, he's going to go to Roberts again, who just wrote the opinion. They know this. They know that what they wrote is an automatic return back to them, which is more of which then extends this runway out beyond, what you can see, what the mind's eye could see in terms of timing for the trial. And that's the problem. If she was left alone just to do her job, she would get this trial up and running by like September, October. But it's this appellate process, right? So what do you think the odds are of we get through an appellate process with the Supreme Court dragging its feet, of having this case up and running anytime, forget the election, between the election and the inauguration?
I think very low. I mean, a couple questions I have, which is, number one, I know she said she'll give them 89 days. Will she stick to that? Will she feel that they need that? Does she have to stick to that? Will she even set a trial date, knowing that most of these things we talked about will not be appealed, right? The motions in limine and all that. But the presidential immunity, as you just pointed out, absolutely they will appeal before any trial. So she might not actually set a trial date, given the fact that what you just said about the Supreme Court and delaying. She might not. So we'll see. But if she gives them the 89 days, and of course they have the right to appeal all of this, I think the chances are very low, if at all.
Fortunately, I think you're right about that. But we got to continue to plug forward. Democracy demands it, and our justice system demands it. And as Judge Ludick said in an interview with me, you got to throw the political calendar out the window. You got to do the right thing, even if it straddles the election day and the inauguration day. But we've got a uncooperative, is putting it mildly, Supreme Court in this area who doesn't care about anything other than supporting candidate Trump in his bid to get reelected. Welcome back. That's a podcast we like to call Legal AF. It's on Wednesdays and Saturdays at 8 p.m. Eastern Time, right here on the MeidasTouch Network. You can free subscribe and help them get to 3 million and build this network with us as we're doing it with our bare hands between now and November the 5th. If you like that kind of clip, you're going to love the full-blown, full-length podcast. We curate the top 4 or 5 stories at the intersection of law and politics, and we bring it to you the only way we know how. With honesty and truth, and with authenticity, talking about things we know what we're talking about as practicing lawyers. Wednesdays, it's Karen Friedman, Agnifilo, and me. Saturdays, it's Ben, Mysalis, and me. And then the leaders of Legal AF do hot takes like this one about every hour right here on the MeidasTouch Network. So if you know all about us, thank you for being part of our audience. If you would like to help us build our audience, take that clip, a little bite-sized version of Legal AF, send it off to people in your life and ask them to join our journey as part of their own. And if you don't know what I've been talking about this whole time, it's okay. I'm Michael Popok. That was Legal AF, and we invite you to join our audience every Wednesday and Saturday at 8 p.m. Eastern Time and everywhere you pick up your podcast from on all major podcast platforms. Until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary. Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.